Hello everyone. For today's Murphy Law Monday, I want to touch on the topic of what admissible evidence can be used in a custody and or divorce battle in court. Specifically, I want to talk about text messages and emails and how they can come into court and what you should be cautious of doing while you're involved in an active litigation. So let's say that a custody case is pending. You guys have what's called a pendite lite order, where a temporary order has been issued by a magistrate or a judge, and now you're in the process of waiting to go to trial. I strongly suggest that you do not text that person, the other party, anything with legalese about the best interest of the child and your factors and your position on it and all this legal jargon that you've probably heard a judge say in court, or you heard the opposing party's attorney say in court. In your text messages and correspondence, I don't believe that that's acting in the child's best interest by trying to purport yourself and trying to, basically police the process and telling the other party what they can and cannot do via text. I think what I suggest is to continue things as you've normally done them in compliance with whatever order you have. If it's a temporary order, if you don't even have a temporary order yet, then I would say proceed as normal. I also suggest to a lot of my clients to use apps that have features for co-parenting. I know there's a co-parenter app that I suggest and have in place for a lot of my clients, where I can log in and I can see their correspondence with the other party. They have a calendar feature where they can say, the child has basketball practice on these days, and on these days he has swim class. So when it's your weekend or it's your week to get him, you'll know what his activities are and where he has to be. Doctor's appointments can be shared. So many things. It runs the gamut. I really suggest that because I think when cases are pending, there always is a breakdown in communication. Of course, no one wants to be involved in a custody battle. Of course, no one wants to text the other party, especially when they said potentially bad things about you in court at the first hearing. I don't know, but I really think that it's important to remember that using legal jargon and telling someone what they can and cannot do is admissible evidence, and it will come in to show that you are basically not facilitating the potential to have an open communication with the other party, which is quintessential in a fight for legal custody. Legal custody boils down to communication. Can the parties actively communicate in the best interest of the child and share ideas and come to decisions in the child's best interest? And if you are not an active participant in facilitating communication, then the court will see that, and the court will, of course, award legal custody accordingly. And I think that that's important to remember and important to keep in mind when you're texting, emailing, or anything like that during litigation, even before, because it's all admissible and it all can come in to show the court that you think you're in control, and therefore joint custody or sole custody is not in the child's best interest. I just want to warn against that because I've seen it time and time again, and I think people lose sight of that when they're in the midst of a litigation. Just wanted to give you guys that tidbit. If you're in need of legal services in the state of Maryland or the District of Columbia, please give my office a call, 240-493-9116, and www.amurphylegal.com. Thank you.